Well, ladies and gentlemen, I have the perhaps unenviable task of trying to keep control of two former Law Lords, Lord Hoffmann and Lord Hope, and a former Lord Justice of Appeal, whilst you have the happy opportunity of asking these assembled gentlemen any question you would like about the areas that we've been discussing this afternoon. We have a mic for that purpose, and please do use it because the room is quite big. But before I throw it open to the floor, I thought that given that Finn Pilbrow did ask the question, we should start with his question. So, the question essentially is it a good thing for the development of our common law that the Supreme Court keeps restating the principles to be applied to the proper construction of contracts? And if not, is there any prospect of the Supreme Court stopping? Lord Hoffmann.
I think I addressed that question a little earlier today, but there seems to be very little prospect of the Supreme Court stopping. Normally, in the case of a one-off contract, the question of its interpretation, you don't get leave to go to the Supreme Court, or at least you didn't get leave to the House of Lords. I used to tell people we're not in the business of doing justice. It doesn't matter if we think the Court of Appeal have got the construction wrong. We only give leave to appeal if we think there's some point of principle involved. That seems to have been abandoned in recent times. And if leave is granted, you give leave on the footing that you need to be able to say why the previous decision was wrong, and that involves a restatement of the principles. So there's no way in which we're going to avoid that happening.
Well, I lived in a slightly different era from Lenny, because as you may have gathered from the way he expressed his example, in the old days when we were in the House of Lords, a lot of these applications for permission were dealt with orally. And I think you were thinking of that. I mean, you said you would tell them that such and such and so and so. Now these things are dealt with on paper. And I think the balance has changed a little bit in the way you deal with these things. The oral argument was quite easy sometimes to just pick apart. But the written arguments we listen to, or rather we read, and they're quite lengthy. And I think there's certainly a more generous approach than you were indicating. May I
just say, by the time I got there, it was all done in writing. When I was at the bar, it was done orally, and if you appeared, for example, before a committee with Lord Diplock, you either weren't called on or you weren't listened to. Yes. But by the time I got there, it was all done in writing.
Well, it wasn't entirely. I was there with you, and there were certainly occasions when we dealt with it orally, but the Supreme Court doesn't deal with them at all orally. But I didn't hear, unfortunately, the discussion earlier today, I mean, you're asking whether the Supreme Court could come back at this, and I fear that they will go on coming back at this. I thought when Lenny came to me in the corridor, in the Law Lords corridor, when we were looking at the investors' compensation case, and you came out of your room with this piece of paper, and on it were the propositions, and you said to me, "What do you think of them?" And I read them over, and I read them again, and I said, I think they were rather good. And I've never really been persuaded there was anything seriously wrong with them. And it's rather disturbing to find people trying to chip away at what Lenny was saying there. I mean, there is a bit of a difference, perhaps, in your last proposition. You perhaps didn't give enough weight to the words as opposed to the commercial purpose, and there's a certain amount of balance there. But I don't think anything has fundamentally changed. Actually, as far as the more recent cases are concerned, it's quite interesting. I met one of the present Supreme Court judges in the street the other day and said, "Is rainy sky still law in the light of what has happened?" And he said, "Yes, it is. Don't read too much into Arnold." So my feeling, I'm a Hoffmann supporter on these things. I don't think anything really has fundamentally changed there, but the trouble is the Supreme Court will be persuaded by a carefully reasoned application for permission to have another go at it. And the one extra point I would like to make is this, that Lord Neuberger, has put a lot of emphasis in trying to achieve a single judgment in the Supreme Court, as opposed to the old Lord Reed approach. approach where we were all invited to write our own. And it's a great shame to see this breaking down in these cases with the way in which different justices are expressing their views in different ways. I'd much rather they went a serious attempt to shrink them down into a single judgment where we can all understand what the point is without having to separate out one view from another.
Well, having been in the Court of Appeal and having to, as it were, pick up the pieces, I would say it's not a good thing at all, because inevitably counsel come along and say, well, there are 2 or 3 cases of the Supreme Court all dealing with principles of construction, and Lord Hoffmann says this in one, and let us say Lord Hope says this in another, and Lord Bingham says this in another, and they're all slightly different. And you're faced with the terrible task of trying to see whether there is any difference, and if so, what the differences are, knowing all the while that you might subsequently be told that in fact you were completely wrong, they were all the same, or they were all completely different according to what you have said. And so I think a little abstention is in principle called for. Will you get it? No, you won't. And the reason is, as David Neuberger said to me, I'm afraid we lawyers and judges, and I think he included the Court of Appeal judges in this, have an itch about construction and implied terms, and we can't help scratching the itch, and we all want to scratch it. And the more you scratch, of course, the worse it gets. So I think, unfortunately, for all involved, whether you're counsel or whether you're judge at first instance, Court of Appeal, and even dare one say at the House of Lords or Supreme Court, it's a bad thing, but it won't stop.
Thank you. Now, does anyone in the audience have a question?
In the light of those remarks, I have a question for Lord Hoffmann, and I apologise for going to my pet subject, which those of you who know me is an area of law replete with badly drafted contracts, namely reinsurance. If Chanterie and Fagan came before the current Supreme Court, would they say that the words actually paid were unambiguous and give them their plain and obvious meaning?
I remember Mr. Jonathan Sumption almost stamping his foot and saying, but my lords, actually paid means actually paid. Well, I mean, it was, I thought, quite clear on the language of that reinsurance policy that it couldn't possibly mean that the money had to be handed over. Does that answer the question? I'm not sure.
No, I'm not suggesting you change your view or that Lord Mance has changed his view. Is it seriously open for 7 or 9 law lords to overrule it?
Yeah. Sorry, he did he?
No, I'm saying Lord Mance hasn't changed his mind. I'm saying if somebody took the point, if somebody reran the point, could 7 or 9 law lords applying the new approach overrule it?
Yes, I see, yes. Well, since I don't believe there is a new approach, I mean, that must be the answer.
I think the answer to the question is, technically, they could. I mean, all right, 7 take one view, it goes before 9, and there's a sort of undercurrent. If you put the thing before 9, something must have gone wrong in the case for the 7. And there's a temptation to explore it a bit more and think, well, perhaps they did go wrong, and restate it in the 9. But as somebody said earlier, are we going to face a Supreme Court of 11 to deal with the turpitude or that thing? And, well, the courtroom is not really very well equipped for 11 people to sit there, but I suppose we have to contemplate it as a possibility.
Yes. Any other questions or contributions? Right at the back.
Right at the back.
It was a question for the panel generally. I understand that Mr. Patel was not actually criminally prosecuted for his conduct, and I suppose in terms of Tom's concerns about wrongdoers bringing these types of claims, whether the panel think that if the criminal law worked properly, where that would be enough of a disincentive to provide the check that's needed.
That's for Richard, I think.
Do you want to do like you? Well, shouldn't criminal law have prosecuted? Patel, so he wouldn't have got away with his crime, essentially.
So what's the effect going to be on a civil claim? There's a little uncertainty here as to quite what the point was that was being raised. But I think, as I understood it, the proposition is that if somebody has been prosecuted and convicted, then does that mean that there will be no possibility of that person being able to claim on a civil claim if it turns out that the conviction was wrong?
So more the point was that there's concern expressed that wrongdoers shouldn't benefit from their actions, but Mr. Patel was not criminally prosecuted, and so maybe our concern about that is more to do with the criminal system, because if people are clearly and seen to be prosecuted for such actions, then the likelihood of them bringing a civil claim, I would have thought, would be much reduced.
Well, I think it depends on your point of view. But plainly, as I think all of the members of the Supreme Court said, both had, in theory, committed crimes, and neither of them were prosecuted, I think. They would, on the facts as we've seen them, I think, be likely to have been proved guilty of conspiracy to commit a fraud. Let's imagine that they were prosecuted and they were convicted. Your question then is, well, would that have made the slightest difference to the claim? Well, I think on Tom Adams' analysis, no, it wouldn't have made the slightest difference, and I'm not sure that it would. But my colleagues may disagree.
Well, I agree with Richard. I wouldn't like to think, actually, that the question in the civil case would depend at all on what view prosecutors took as to whether a case should be brought before the criminal courts. And there are all sorts of misadventures that may occur if you try to bring a prosecution anyway. So I think you have to look at them entirely independent and judge the turpitude by reference to the facts as you know them in the civil case.
Yeah, I agree. I think the case appears to have been argued on the assumption that they were liable to be prosecuted and convicted. So it doesn't, and sentenced. So it doesn't terribly matter whether it actually happened or whether it was merely assumed that it would happen or could happen.
It gives me the opportunity to say that I wish Tom had been with me on yesterday, when I had a discussion with my window cleaner, because he said he would clean my windows, but he insisted that it was on condition that he was paid in cash. Now, we all know why he wanted to be paid in cash, because the assumption was he was not going to enter it into his profit and loss account and pay tax on it. And the question is, was there some kind of degree of moral turpitude in this discussion? I mean, would I have been able to say, he having cleaned my windows, I don't think you should get my money because you're simply not going to declare it for tax purposes? I think it's a question of degree, and obviously it's not a criminal offence, but Tom might have been able to make a joke or two out of this discussion. There was no illegal act in cleaning my windows, of course. It was entirely what he was going to do with the money, or how he was going to deal with his accounts after he got my cash.
Both guilty of a conspiracy to defraud. Both guilty of a conspiracy to defraud in those circumstances.
Could be.
I have a question, if I may, from a practitioner's point of view. We heard in the first session that as a matter of contractual construction there are no principles, apart from what does the contract mean. And then we heard from Tom as regards illegality, that the structured discretion that the majority of the Supreme Court favoured means that it all depends on the gut feel of the judge. That means surely that at first instance, when you're faced with these sorts of problems, so much depends on the luck of the draw, which judge you get. And is that not a problem in terms of giving advice to clients and the certainty of our legal system? Well,
some cases are difficult. And people may differ about what the answer is. So to say, well, it depends on the luck of the draw, you might equally say it depends, as I think some American academic once said, on what the judge had for breakfast that morning. These things are unavoidable, but I think one mustn't exaggerate the extent to which this is the case. I mean, very, very few contracts, if you take them as a proportion, actually go to court with serious disputes about what they mean. Normally, things are perfectly clear.
I think I broadly agree with Lenny on whichever of the two chapters one's thinking about. The degree of uncertainty, the cases which are going to give rise to uncertainty are relatively few. But I must say my feeling is that the safest course in both cases is to try to find some kind of principle. I'm very disappointed by the Mirza case because I'm assumption man in that case. I think that he was absolutely right to try to hang on to the principle. I wish actually that Lord Roger, my great friend Lord Roger, had been present, because as soon as you see a maxim in Latin, he would have then gone right back to the roots and explained what it meant. And I'm pretty sure he would have found an anchor in the principle that lay behind the maxim. And he wouldn't have gone along with the Toulson approach at all, I don't think. But it does create a difficulty, and if I were you, at first instance, I would try somehow to find a principle. How you present it to the court may involve a certain amount of moving around and trying to fit it into the way it's expressed by others. But basically, there surely must be a principled approach to all these problems.
It's important, in my view, to look at it in the international context as well. One of the big selling points that's always put forward for English law is that it is certain and it is predictable. And the argument goes that you can go to a lawyer and he can tell you what the law is, and within a margin of error that's always necessary in cases which involve some factual evidence, you're going to be able to predict what the outcome will be. Well, if that is undermined in any way, then it undermines a big selling point in the international world of business and choosing a particular law for your business transactions. And I think that's the danger. Of course, the lawyers mustn't make too much of it, because it is easy, as we've seen from the analysis of the cases both in the first session and the second session, to, as it were, poke holes and inconsistencies in what's been said. And anyone can do that if they pore over a case for long enough. But I do think it's something that is important for judges, particularly appellate judges, to bear in mind. And it comes back to the point I was making earlier. If you do restate things, or you restate a principle which is the same principle, only you use different words, then that creates the possibility of uncertainty. And as David Hope said, if you have the same case and you have 3, 4, 5, or even more judgments on the same case, all of which come to the same result, after all 9 in Mirza came to the same result, but stating it in different ways, then that creates uncertainty. And I do not think that is a good thing for English law as a product in the international world of business.
Well, I agree with all that, but I don't think that the law should pretend to greater certainty than the nature of the subject matter will allow. And in the case of the construction of contracts, for example, you can say, well, you've got to work out what it means. But if you're going to pretend to be laying down rules as to how you find out what it means, you're going to produce arbitrary consequences.
I don't disagree with that.
There is another aspect to this that one ought to bear in mind in thinking about the role of the judges, and that is that if the judicial function is regarded as unsatisfactory by the wider public, you may be driven into setting it all out in a statute. And that's really, I suppose, what the Law Commission is there to do. I would much rather leave it with the judges, actually, and because the statute is going to go, as Lord Tilson was really indicating, by setting out a whole set of rules, and then you argue about the statute, and you get away from the basic principles. So however imperfect the judicial function is, I'd rather hang on to it than be driven into a statutory reform.
I have a question down at the front.
Given that now we're looking at all sorts of proportionality...
Can you use the mic just so that...
Given that we're now looking at all sorts of proportionality factors and some sort of balancing act under the various factors set out in Toulson and Lord Neuberger, does that mean there's going to be a much bigger role for the first instance judge? And will the Court of Appeal and the Supreme Court be saying... well, the judge, we may not agree with the judge, but he didn't get the Balancing Act wrong. Yeah. And therefore, could it be that rather than all these cases going to the Supreme Court, they'd all be decided at first instance?
Yes, I think that's bound to be the case. As soon as you have decisions which depend upon weighing a multiplicity of factors, and the vaguer they are, the more reluctant an appellate court is to interfere.
Yeah. No, I agree with Lenny. I think that must follow.
Yes, that is true, but don't forget, if you have a Court of Appeal or a Supreme Court that says, well, yes, he took all the relevant factors into account, but the result is wrong, they'll give permission to appeal. It happens. So, although in principle they shouldn't, it does happen. And an example is Rainy Sky. There's nothing wrong with Nick Patton's judgment. There was perhaps something wrong. Well, I think the reason why it went was because there was outrage in the city at the result, but he dealt with all the right factors. But there was such pressure, and people said, oh, it just gets the wrong result, nevertheless. And so leave to appeal was given. And I think that's what can happen.
But that, if I may say, is not an example in point, really, because the question in Rainy Sky and in all these cases was not what conclusion you come to by weighing up a lot of factors and balancing incommensurables against each other. The question was, what does it mean?
It was only by way of example.
There's another question towards the back.
My question's for Lord Hoffmann, and it actually follows from exactly that. What does the contract mean? Earlier today, you said that perhaps you didn't express yourself clearly, but all you...
Sorry.
Earlier today, in relation to Belize, you said that perhaps you didn't express yourself clearly.
Yes, quite.
But all you were saying was that the question for the court is what does the contract mean?
Yes.
And everything else you said necessarily followed from that starting point. Nevertheless, we know from Marks and Spencer and BNP that the Supreme Court, for whatever reason, disagreed with what you said in Belize. My question is, why do you think that is? Were you being modest, or do you genuinely think you didn't express yourself clearly, or do you think they actually disagree with the substance of what you said? And if they disagree with the substance of what you said in Belize...
I must confess, I didn't find it easy to follow quite what they were saying. They seemed to be suggesting that what I had said could be misunderstood and could lead to terms being implied when in circumstances in which you couldn't necessarily say, well, that must be what the contract says. Well, if that is the case, and it may well be the case, then I expressed myself badly. The other thing I think that they raised was that I'd spoken of it as being a question of, I can't remember whether it was construction or interpretation or whatever, and they said, you can't have construction or interpretation of words which aren't there. And a implied term is inserting into a contract something which is not expressed in words, and that can't be the subject matter of interpretation or construction. Well, I don't want to get into arguments about what counts as interpretation or construction and so forth. I would think it would have been clearer if I'd said, the question is that what the contract means? Because if you say the contract has to have such and such a term implied in it, and if you are committed to the proposition that you're not entitled to change the contract and make it a better contract or a more reasonable contract, it must follow that you're saying that is what the contract means.
Finn, again.
Lord Hope, you talked about Lord Neuberger's desire to try and get a single judgment out of the Supreme Court. But the flip side of that is we've all had difficult attempts trying to understand what judgments of the ECJ mean, because they are so condensed to produce something that everyone agrees, it's difficult to follow. And how does one strike that balance between producing a single text that everyone agrees on, but still making something that's possible to follow?
Well, there's a fundamental difference, isn't there? There cannot be a dissent in the ECJ. And I don't think for a moment Lord Neuberger, in trying to persuade us all to agree to a single judgment, was saying we couldn't dissent if we disagreed. So I think there is that safety valve, and it makes it easier. If you are, assume you all agree on the result and are broadly agreed about the way to reach it, his view would be, let's put it into a single judgment. It could be, as quite often happens nowadays, that 2 or 3 people put their name at the top. So, and indeed, they will have all gone over it a lot by revising it and making subtle changes, but they're all on the same side. I think the great problem with the ECJ is that they're tied to this, I suppose, French rule that you can't have a dissent, you can't express a disagreement, but you've somehow got to all come together in the formulation that is put out on behalf of the court. And that is one of the great flaws, speaking purely personally, of the ECJ system. And you don't find it, actually, in the European Court of Human Rights, because, of course, there is a dissent there, and very often they're very interesting, but the majority are not tied to trying to agree with them.
Anyone else? Oh, yes, Peter.
Suppose you're being sued under a contract which both you and the claimant knew was for an illegal purpose. Can you still cheerfully put forward a defense of illegality and hope to get away with it? Or might it be more difficult nowadays?
Well, I think the answer is that under the Toulson regime, if I could call it that, illegality is bound to be raised as a defence. Whether it would succeed or not will depend on going through all the factors and so on and so forth. And perhaps it wouldn't. If you both entered into it knowingly that it was for an illegal purpose, say some money had been paid by one to another and then nothing had happened, you could get it back. If there'd been a breach of contract and you wanted to claim profits, well, that might make it more difficult. It looks as though everything's up for grabs.
And it's changed the scene, because I always thought, I must say, that it didn't matter whether they knew or didn't know that it was illegal. That is simply a factor that's not relevant. The only thing that matters, was there an illegality, a turpitude, if you like, which taints the whole bargain? And you rely on, it may be quite disreputable. You knew perfectly well that there was an illegality there, and you had a good claim, a good defence to claim back for the money. But you're entitled to do that. You're entitled to rely on the illegality. So I would have thought it was an irrelevant factor, but I'm sure Richard's right that one really can't be quite so sure now in view of what's happened.
Well, just take one more, because we're then approaching the witching hour.
I have one last question on the illegality point. We have heard Tom say that it is now down to the gut feeling of the judge. Is there, playing devil's advocate for a minute, a possibility that we are over-dramatizing the effect of Patel and Mirza, in that it has always been about what the gut feeling of the judge was. That is why we had an attempt at expressing it in Tinsley and Milligan, exceptions to Tinsley, exceptions to the exceptions, in trying to find the right balance. And what the majority in the court, as the Supreme Court has now done, is actually to drop all pretenses and to give the tools to the judges to actually now freely do what they think is best in the circumstances of the case.
It's a very interesting question, actually. As you were expressing it, the thought that passed through my mind was, where does the judge start? Because you could start from a gut feeling as to what the right answer would be, and then you try to rationalize it and see whether actually you can work it out to reach the answer that you had formed at first impression. Some judges will try to hang on to that first impression. Others are rigorous and will find that actually it doesn't work, and they have to abandon the first impression and come back to the result, which is the product of careful thinking. And it really depends, I think, on the individual. I don't know whether Lenny, who sat at first instance more than I have, do you gather what I'm saying? You understand what I'm saying?
I missed that.
Yes. What I'm saying is that it all depends on where you start.
Yes.
You can form a sort of initial impression before you begin to work it all out,
yes,
as to what the result should be.
Yes.
And some judges will do everything they can to justify their initial result by the reasoning.
Yes.
And there are others who have a different approach and say, well, that was my first impression, but let's look at the reasoning and what it leads to. And
yes,
they're able to persuade themselves that their first impression was wrong.
Yes.
But not all judges do persuade themselves that their first impression was wrong.
That is the case, yes. I vividly remember a case in which I was in the Court of Appeal with David Hurst and Johann Steen. And we discussed the case before, and it was a case about whether the government ought to be entitled to concrete over a bird sanctuary at Sheerness Harbour. And this was being objected to by the Royal Society for the Protection of Birds. And it was whether it was contrary to a European legislation. And we'd had a discussion beforehand, and we'd all come to the conclusion that the birds had to lose, that the government was entitled. And Richard Gordon then came and argued the case before us. And after 10 minutes of his argument, it became clear to me that he was right, and we got it entirely wrong. So eventually, at the end of it, the other two were completely immovable. And so I wrote a dissenting judgment in favor of the birds and the other two. Not only did they say I was wrong, but I was so wrong that it was clear that I was wrong. It wasn't a matter that even need to be referred to the European Court in Luxembourg. And it then they then appealed to the House of Lords, where Lord Jauncey said, this is ridiculous. You can't have something which is clear and the members of the Court of Appeal disagree as to what the answer is, and they sent it off to Luxembourg. Yeah. But yes, one does sometimes change one's mind.
Not only that, but I do think actually that the process that David Hope has described is one that is subconsciously done by most judges. I think when you come across a case and you see the submissions in writing, and you perhaps read through some of the other documents and the pleadings, you form a view. You form a view about the merits of it. And then you hear the argument, the oral argument, and then you go away and you think about it. And then you do what David has described. What you do is you test your first thought against the principles of law that are there, against the facts as they've been found by the judge at first instance if you're sitting in an appellate capacity. And you test it all and see whether your first instincts are right or wrong. And if they're wrong, and you've got to say so, as Lenny says. I think what you're saying is that, in effect, what has happened before the Patel and Mirza case is that judges were doing that, but they were sort of creating a kind of layer of principles by creating rules and exceptions upon exceptions. And they were doing nothing more than looking at a whole series of factors, but doing it in a perhaps more rule-bound way. And now that's all got to change. Well, that may be right. I don't know, but I am quite convinced that when a judge looks at something, when they're actually deciding whether their first instincts are right, they're doing it by looking at what the law is. The difficulty that may be the case now with the illegality defence is that it might be a more widespread number of factors that they have to try and test their instincts against than there were before.
I can think of two really quite dramatic examples at the House of Lords level of a judge changing his mind after the first impression. One of them involves Lenny, which was the last case that Lord Gough heard, which was a case about unjust enrichment. You may remember it, where after the discussion, Lord Gough and I were in the minority, and it was a bit of a bitter pill for Lord Gough, because it was his last case on his specialist subject, and the majority were against him, and the majority included Lord Hoffmann, and we all went away, and in the course of the summer you changed your mind, and Lord Hoffmann won the case, his last case, because the majority had been created by you working it through and coming to what I thought was the right result. And the other was equally dramatic, where we were hearing a Scottish case about a question of security rights, and Scots law is quite different from England. And Lord Roger, who was the other Scottish judge, made it quite clear from the start of the case that he was agreeing with the two English judges who were sitting opposite him, and disagreeing with me, the sole Scots judge left on the other side, and we were presided over by Lord Bingham. And for most of the hearing, it looked as though I was going to lose by 1 against 4, because Lord Bingham would obviously go with the majority view. But the hearing was interrupted by the state opening of Parliament. Now, this meant that in the House of Lords we couldn't sit. And for a day, Lord Roger disappeared into his room and did a whole lot of research. And when he came out of his room the next day, he'd completely changed his mind. And so he agreed with me. And it was 2-2, 2 English, 2 Scots. And Lord Bingham said, well, if the 2 Scots agree, who am I to disturb the drawing rooms of Edinburgh by disagreeing with them? so we won. But they were both dramatic.
Five love,
yeah. It was really dramatic changes of mind. And it was there was a very firm first impression, certainly in Lord Roger's case, and I think in your case too, which by further research and thinking was changed. So some judges do change their mind, but not all of them.
Well, ladies and gentlemen, we've come to the time when we must draw this to a close. I'd like to thank you all for coming. I hope you found it informative. I'd like to thank Finn Pilbrow and Simon Burt for arranging this afternoon. It really has been an excellent conference. And most of all, I'd like to thank all of our panellists for their time and their really interesting contributions. And could you join me in doing so in the usual way?